Good afternoon. As people are filtering into this webinar, I just want to make sure that the sound is good and you are all getting ready to learn and educate yourself about a very, very cumbersome new law, new regime. It's my pleasure to be here, and I just want to make sure that before we commence and everybody gets going, that we have excellent sound so there's no inability to hear what we're going to be going through. Before I start, I of course want to congratulate all of you for making the decision to participate in this webinar. Admittedly, this is very tricky stuff, and I have never in my 25-year career as an attorney been placed in a situation where the law is so cumbersome and challenging and moving and evolving that it is oftentimes difficult to gain a mastery over the information. And let me start by saying this. Today is an introduction to the COVID-19 legislation. It is going to provide you a working understanding of this information, but rest assured, if you have a particular question regarding a fact pattern that you are experiencing in your day-to-day operation of your rental property, by all means, email me and we'll set up a time to talk, because this stuff is particularly cumbersome for those jurisdictions that have a local ordinance and a local eviction moratorium as well. With that stated, we are now going to commence the webinar. It's my pleasure to be here. My name is Daniel Bornstein. I've been a practicing attorney for 25 years. Many of you know me in close proximity because I've provided legal services for you. And my hope is by virtue of you participating and staying focused, you've got a better understanding of what we are all facing between now and at least March of 2021. So let's begin. The agenda for today is as follows. I'm going to talk about the Tenant Relief Act. I'm going to especially focus on a September 30th date and a document requirement that all of you should be familiar with. We're going to talk about debt that accrued from March of 2020 to August of 2020 and the hardship notification. Then we're going to discuss the new rule as it relates to September 2020 to January 2021 debt. We're going to talk about small claims and the relief that the state has afforded landlords in pursuing small claims cases for COVID-related rent debt. Discuss additional protections that tenants may have. And then I'm going to focus on a review of San Francisco County and Alameda County rules because those are different. And what I hope to do is through this process, you come away with a better understanding of what you're going to do when you're faced with a landlord-tenant problem during this very, very admittedly difficult time in our society. So with that stated, let's jump in. By September 30th, 2020, you must serve any tenant who did not pay some, that's a partial, or all of the rent accruing between March 1st and September 1st, the information notice regarding the Tenant Relief Act of 2020. I provided you a picture of the information notice. This doc was drafted by the California Apartment Association. Some of you, members of different trade organizations, may have a similarly looking document. The Apartment Owners Association put out another document. What you need to do is, if any of you, whether you're a property manager, a management company, whether you're a landlord, whether you're advising someone, if you have tenants in California who have not paid rent between March and September, even if it's a partial payment, even if you're carrying a small balance, you need to send this document. If you don't have the document, we'll make sure you get one. This document needs to be served by September 30th, and it needs to be completed properly so that you are preserving your rights to pursue your rights under the new AB 3088 in order to collect rent through other means in the future. What this does is basically put a tenant on notice of what the laws are. Also, this notice should be served on tenants who did not pay rent from September 1st through and including January 31st, 2021. You want to serve this notice prior to serving any other notice on these tenants. So for example, if you have a tenant who has paid you rent through August, paid rent timely in September, but in October did not pay you the rent they owe, you need to send this document out. That's your insurance that you are complying with the state law. Once you've sent out the document, and I always recommend, complete the document, make a copy of the document, make a copy of the envelope you send to the tenants. If you're posting the notice on the door, take a digital photo of it. You want to have proof that you sent and served this document. Sorry. Under the new Tenant Relief Act, here are the core components of it that you need to be familiar with. Of course, we've just gone over the document you need to send to all those tenants who haven't paid you timely rent. Tenants now will have 15 days to pay rent demanded or return a declaration of hardship in response to a landlord's notice to pay rent or quit. For many of you, you're familiar with a 3-day notice to pay rent or quit. Well, welcome to COVID-19. Notices to pay rent or quit commencing now are 15-day notices to pay rent or quit. And when you serve a 15-day notice to pay rent or quit, you must attach a hardship document permitting a tenant to complete the document informing you that they are alleging a COVID-related hardship. I will show you a copy of that document in a couple more slides. The rule is as follows. If you are holding rent debt from March 1st through and including August 31st, the general rule is tenants cannot be evicted for non-payment of rent if when you serve that 15-day notice to pay rent or quit, they complete the declaration of hardship claiming that their failure to pay rent was as a result of a hardship involved with a COVID-related impact, such as loss of a job, additional expenses. And so essentially you serve a 15-day notice to pay rent or quit, you provide the hardship document, and you wait to see what the tenant does. If the tenant likely fills out the hardship form, that rent debt is no longer debt that can be acted upon through an eviction action. And I want to emphasize, right now I'm giving you the general state law rules, and then we're going to get to the particular nuances of San Francisco and Alameda County. So we know for March through August debt, you serve a 15-day notice with the notice of hardship. If the tenant pays the money, wonderful. If the tenant fills out the hardship form, the debt is not something you can proceed upon through an eviction action. It will convert to consumer debt, and we'll talk about that. For debt that accrues between September 1st and January 31st, 2021, again, it's a 15-day notice. You served the 15-day notice because your tenant did not pay you October rent in the amount of $4,000. If the tenant is served a 15-day notice and you wait, and on the 14th day, they fill out the hardship form and they pay you 25% of the rent, nothing you can do. And also, if they fill out the form in October after you serve that 15-day notice, they have until January 31st, 2021 to come up with 25% of the rent for October. Once they do that, you are not going to be evicting the tenant for non-payment of rent, but instead you will be entitled to pursue the rent debt in small claims court or in other court. Let me say that again, and I'll give you an example. Let's say September, October, and November, a tenant whose rent is $1,000 a month does not pay you for 3 months, September, October, and November. December 1st, you authorize my office to prepare a 15-day notice to pay rent or quit. We attach the hardship form to the document and we wait 15 days. If the tenant pays the debt, matter's over. If the tenant signs a declaration of hardship, you are done with filing an eviction. You now have to wait to January 31st, 2021 to see if the tenant has come up with 25% of the $3,000, which would be $750. The balance, $2,250, you'll have to go to small claims court to collect it. That's the core understanding of COVID-related rent debt. Be advised, high income earners over $100,000 in household income or 130% of median household income must not only provide you a document declaration of hardship, but they have to provide documentation of financial distress. So if you believe your tenants are above 130% of the median household income for that location, you can demand additional income request or additional documentation. Beginning October 5th, tenants can be evicted if they fail to return a hardship declaration to the landlord and didn't pay the rent. However, this rule is subject to constraints under San Francisco eviction moratorium rules and under Alameda moratorium rules, which means this is a general overview for the state, and then you have to know the rules and regulations that you must follow depending upon your jurisdiction. Be advised though, evictions for nuisance and other just causes have been entitled to commence as of September 2nd, 2020, but again, subject to local rules. Interestingly, the Tenant Protection Act has extended just cause protections for just cause eviction rights to all tenants until February 1st, 2021, with limited exception. So for those of you who are in a jurisdiction where there is no just cause eviction rules because of an exemption under state law, because of this new rule, at least through February 1st, we are going to be subject to just cause protections. Why? Because the public policy underlying this is we don't want to have displacement of people during a pandemic. And so all things being equal, landlords, property managers, brokers, investors are responsible for at least ensuring the vast majority of tenants and stability in their tenancies. So for those of you who think that you can proceed with an eviction action because you're not subject to just cause protections, unfortunately, as of February 1st, 2021, before February 1st, 2021, you must ensure that you follow just cause protections under the ordinance. Call or email my office before you do anything. It's tricky. And again, today is about introducing you to the information. You will not have a mastery of it, but it gives you an understanding of it. Let's move on. Recovering unpaid rent debt. If a hardship is filed and other requirements followed, such as payment of 25% of the rent for the period of September through the end of January, any rent debt that accrued between March 1st and January 31st, 2021 is not a ground for eviction, but will be converted into consumer debt recoverable through civil courts. What does this mean? It means for 25 years of my legal practice, the ability to serve a 3-day notice on a tenant demanding rent is a very aggressive document, because if a tenant does not pay the rent, you have perfected your right to seek the removal of the tenant from the property. Because of the new law, for this period of time, you're not going to be able to recover possession of the premises for rent that accrued during this period of time if a tenant follows the rules outlined under this law. Instead, you'll be able to take the debt and go to court. What court? Well, what this law has done is empowered small claims court to allow landlords to bring numerous causes of demands in excess of $10,000 and seek judgment against the tenant for that debt. The debt can only be pursued beginning March 1st, 2021. Now, what does that mean? It means that if you have a tenant who fills out the hardship form and they didn't pay you $4,000 of rent in April of 2020, on March 1st of 2021, you're perfectly entitled to file a small claims action against the tenant seeking a judgment for $4,000. And many of you thinking, well, what good is the judgment going to do? It doesn't remove the tenant from the premises. It only allows me to have a piece of paper that says the tenant owes you the money. I don't disagree. It's better than nothing, but it's certainly not possession of the unit. And this is the compromise and the policy reached so that a landlord doesn't waive the rent that's unpaid, but can secure a judgment for it. For those owners who are interacting with tenants who are careful and concerned about their credit, careful and concerned about their future ability to get loans, to qualify for loans, not to have judgments on their record, the risk of going to court will help you get the money paid. For those of you who have tenants who may have family debt, may have wage garnishments, may have bad credit, the risk of another judgment may not be that compelling, and the stability of being inside a unit much more interesting than the risk of being faced with a monetary judgment, because they may say, you know what, owner, stand in line. I have many people waiting for me to pay, but because of COVID-19, I lost my job and I'm not able to pay, which means, in theory, a tenant could not pay rent from March through August and then pay for September through January 25 cents on the dollar of all rent from September through January, and the only approach you can take is to file a lawsuit in court. You don't have to go to small claims court. You can go to regular court, civil court with an attorney, but small claims is easier. It's more simple. For those of you who are property managers, or you own a property management company, and you may have 50 tenants who are going to have accumulated debt through COVID-19, come March, my suggestion is either work with my office or do it yourself and file multiple 30 small claims cases set for the same day of court, so you don't have to run to court repeatedly to get those judgments in place. You can go to regular court, but that involves an attorney. Remember, small claims, you can't have attorney representation if you are a plaintiff pursuing the claim. If you are a defendant, you can't have an attorney present at that first lawsuit. If you appeal the small claims result, you certainly do have the right to attorney representation. So that's how unpaid rent debt during COVID-19 is going to be recovered. And I use the word recovered loosely with a big asterisk. You may get a judgment, but collection on the judgment, it may be very hard to come by. And just FYI, if you get a judgment, it's tricky to do collections. If you then get a collection company to go and seek collections on that judgment, collection companies can ask for up to 40 to 60% of the judgment in order to proceed against the tenant. So all things being equal, it would have been much more easy to go back to pre-COVID times and simply serve a 3-day notice to pay rent or quit for debt arising, because the loss of housing is a much more severe risk than a judgment for money being levied against the person. So Be advised, this is the general understanding of the new COVID Tenant Protection Act. Let's look at the hardship document. So I have repeatedly informed you that when you serve a 15-day notice, and this would be a 15-day notice for rent due March 1st through August 31st, 2020, with the 15-day notice to pay rent or quit, you're to provide a declaration attached to the notice that gives a tenant information about how they can assert a COVID-related financial distress. And if you look at this, the threshold is rather low. Loss of income, of course, increased out-of-pocket expenses, increased expenses due to health impact, childcare again, or elderly disabled. And then number 6, other circumstances relating to COVID-19 pandemic that have reduced my income or increased my expenses. You send that to a tenant who owes you money, the likelihood is it's going to come back signed. And I want to point out number 6, and I've had this happen quite a bit. I've had clients tell me, I've got a tenant who's paying the rent, not paying the rent. They're still employed, but they lost some subtenants or roommates. And so they're not able to pay the full amount of rent because their roommates are gone and they can't find other roommates because of shelter in place. Why should I have to lose rent because they're fully employed? Well, I think you're out of luck because number 6 says other circumstances related to COVID-19 that have reduced my income, and maybe subtenant rent would be treated as income and therefore they could assert this. And remember, all they have to do is fill this document out and you're done. And I want to make sure you understand the declaration is 2 different declarations, one for rent due March 1st through August 31st, and another declaration for post August 31st, because after August 31st, for September, October, November, December, and January, we have already talked about the additional requirement that a tenant must make, which is they have to pay 25% of the rent unpaid at least before January 31st to ensure that they're not subject to an eviction. The only caveat is if you've got a tenant who is household income over $100,000 or makes over 130% of the median income, they're going to have to provide additional documentation for due diligence purposes. But the vast majority of people, all they've got to do is fill out this declaration and you're out of luck. I want to point out this is a document that was prepared by the California Apartment Association. I'm presenting this document for education purposes only, but I will tell you if you do need documents, I'm happy to provide them to you. I want you to understand that there now is a whole new protocol for the next 5 months that you have to follow. So you really have to take a deep breath and not do what you've done pre-COVID when looking at tenant-related debt. Additional protections for tenants. And I know this is getting frustrated, and I know you are suffering from mental indigestion, but let's continue so you understand it. If for you have negotiated a lease in a different language, the hardship declaration forms need to be in the tenant's language. We can get you those those documents if necessary. But if you have a wonderful group of tenants who express and communicate in a different language than English, and that's how you negotiated the agreement, the hardship document also has to be that. Another emphasis, remember, and this is wacky, I have told you that a tenant has to fill out that hardship document that we just looked at in order to prevent themselves from being evicted. However, and this will give you indigestion and heartburn, if a tenant did not fill out the hardship document and you did decide, because they didn't give you the hardship document, to file a lawsuit against them, let's say you're in Walnut Creek, if during the eviction action they have a justifiable reason for why they did not return the hardship declaration to the landlord in the 15-day period, there will be a hearing by the court to determine whether they have good cause And if they can show that they have a hardship, you're out of luck. You won't be able to recover possession of the unit. That's why before we start an eviction for non-payment of rent, regardless of where we are in California, you really want to think long and hard as to whether you want to get involved in this roller coaster, because this law was to ensure stability of tenancies in their units, despite their failures, whether it's to pay rent or even to fill out a hardship declaration on a timely basis. I want you to also remember, landlords must provide a notice that details the rights of the tenant. And that's that first document we provided. And you want to make sure you get that out before the end of September. Evictions for non-payment of rent during this period are going to be concealed and not publicly available. And surprise, surprise, there are new penalties for landlords or property owners or investors who resort to self-help evictions without following the required court process. If you don't follow the rules, you face a criminal or at least a monetary sanction. What does that mean? Well, for you folks, you now know it's a 15-day notice. You now know that you've got to attach the hardship document to the 15-day notice. The vast majority of Californians who don't read the news, who don't understand that it's important to stay familiar with all the changes in the law, they may be serving a 3-day notice. And there may be hundreds of 3-day notices out there floating about. Well, they didn't follow the law. If they do not follow the law and attempt to file an eviction action, they're going to lose because they're not in compliance with the 15-day notice and having served the hardship document. And not only do they lose the unlawful detainer action, but they can face a penalty for any violation of this statute, which would include not providing the necessary documents. So congratulate yourself. You now know that there is a financial penalty for being ignorant. I've known that my whole life. You stay ignorant, you face financial consequences. Stay abreast of the law, keep familiar with it, and the most important thing is getting a working knowledge of it. No one is going to master this in 1 hour setting, but you will understand the risk of getting yourself involved in something that you're not very familiar with. And I can only tell you from example that many people come to my office seeking legal advice after they have made a mistake, and I have to remind them, you've made a mistake, you've decided to file an unlawful detainer action, your documentation is not good, the tenant attorneys are going to be able to see that your documentation is not good, we're going to need to have you dismiss the case and start over. We don't want you to do that. The optics of filing unlawful detainer actions during COVID-19 are not ideal, and the rigorous statutory requirements right now are so difficult that we want to be very, very sober and conservative when deciding whether we're going to pursue an unlawful detainer action or not. So these are the general rules, and let's talk about the patchwork of local rules. Existing local ordinances, such as the San Francisco Rent Control Ordinance, the Rent Stabilization and Arbitration Ordinance, and all the iterations of it, the eviction moratorium in Alameda County. The existing ordinances will have full effect until they expire, but local actions that occur after August 19th cannot take effect before February 1st, 2021. That's the language of the state law. The state law clarifies that nothing in the act interferes with a city or a county's ability to adopt an ordinance that requires just cause consistent with the state law, provided it does not affect payments due between March 1st and January 31st. Why March 1st and January 31st? Because this tenant protection ordinance, which is 20,000 words of new law, has already inhabited the issues involved with March debt through January 31st debt that we've talked about since the commencement of this webinar. What does this mean? It means as follows. We have just gone through what the state law anticipates, which is a 15-day notice to pay rent or quit for March through August debt, a 15-day notice to pay rent or quit for September, October, November, December, and January debt, the attachment of the hardship document, and the right of a tenant to fill out the hardship document and preclude an eviction. I want you to understand that San Francisco has its own rules, and therefore what I have spent 30 minutes talking about, you now have to put in a compartmentalized box and recognize the following. San Francisco, as of July 27th, prohibited landlords from evicting tenants for non-payment of rent due to a COVID-related impact. You cannot impose late fees, you cannot seek this, and a tenant cannot be evicted for non-payment of rent that became due, as long as it's directly or indirectly related to a COVID hardship, even if the rent is not paid. What does this mean? It means that I would not recommend at this point in time serving 15-day notices in San Francisco, because I don't believe that you're going to be entitled to proceed with an eviction in San Francisco, because San Francisco already has rules that were established. In other words, San Francisco has created a permanent eviction moratorium for missed rent payments that became due, as long as that tenant can show and demonstrate a COVID-related hardship. It only limits evictions. Tenants are still obligated to pay the rent, or you can bring a civil action. In San Francisco, a tenant will have 6 months to repay the debt that arose. So for instance, if a debt arose in September, they'll have until March to pay that debt. What does this mean? It means that for you folks who have property in San Francisco, you've got to be particularly careful about what you're going to do. I'm here, my team is here, ready and able to help you make good decisions about what to do with San Francisco debt. You're perfectly entitled to proceed in small claims action. If the debt is large enough that you don't want to proceed in small claims, you can proceed in the regular court. You just have to follow proper protocol. The rent is not waived, but you're not going to be able to recover possession of the unit for COVID-related rent debt that arose during this period of time. And right now it's March through September. There is also in San Francisco a rent freeze. The rent freeze applies to all rent increases and pass-throughs that are effective between April 7th and October 21st. I want you to know that as we go through this, a wonderful resource is the San Francisco Rent Board's website. On their front page, they have all the information necessary for you to get tangled and twisted, but it provides guidance on the rent freeze and under what circumstances you're entitled to the banked rents, when you're entitled to the bank rents, and how to handle it. But be advised, right now isn't the time to be raising rents. And I can only say this, if you go to SF Gate, you'll see the volume of articles talking about landlords being desperate because of the reduction in fair market rent that is accruing or occurring throughout our community. So if you have the ability to not consider a rent increase, I strongly recommend not doing so to maintain compliance with the law, whether it's the anti-gouging aspect of the state or the local rent freeze. Preston. So I call this Preston number 2. And the reason why I call this Preston number 2 is Dean Preston, the supervisor, was responsible for converting San Francisco COVID rent debt to consumer debt so that you could not recover the possession of the unit, but you could only go to court and get a monetary judgment. Well, after he was successful in pursuing that, Preston has presented a new proposal. It is not law yet. However, if I had a gamble, believe that it will be forthcoming. And the rule will be that through January 31st, no landlord is going to be able to recover possession of a unit unless due to violence, threats of violence, or health and safety issues. What he's asking for and what I think is going to pass is that owners, property managers are going to be held in a state of abeyance through the end of January. And the only type of evictions that we will be looking at: violence, threats of violence, health and safety. What are we talking about? Criminal conduct, narcotics use, arson, those very significant threats to public safety. All others are going to be delayed. For instance, you buy a property, it has a tenant in it. If this legislation passes, you may not be able to do an owner move-in termination until after January of 2021. So be advised, it's very important for all of us to keep track of what's happening. This law may come into effect. I believe it will. The mayor's eviction moratorium rules is on its 12th amendment. And I can only say that I've never faced in my life and career as a professional attorney so many nuances, added rules, new laws coming into effect that alter the traditional relationship between landlord and tenant. Rest assured, if you are contemplating an eviction for nuisance, contact me, I'll give you advice. Nuisance is within the health and safety exemption, and we are actively pursuing those claims that arise that are serious, but someone playing excessive music at night may not give rise to the level of seriousness I think is necessary to pursue a nuisance claim. It's a judgment call, and I welcome the opportunity to assist you in evaluating that. Remember, this is not law yet, but it's likely to become law soon. Alameda County. So Alameda County is a huge county. And while I was busy learning the Oakland eviction moratorium, the Berkeley eviction moratorium, Emeryville's rent ordinance, and Just Cause eviction ordinance, Richmond's in Contra Costa County, Alameda County supervisors put out a temporary moratorium on residential evictions, which expires 60 days after December 31st, 2020, which is approximately March 3rd, March 1st. Remember, in Alameda County right now, there is an eviction moratorium through through February of 2021, approximately 60 days after December 31st. No residential evictions. No evictions for late fees, fines, no imposition of late fees or fines. It is an absolute defense to an eviction action, or what we call an unlawful detainer action. If you serve a termination notice during this period, or if a notice of termination expired this period, or an eviction complaint has been filed or served between March 24th, 2020 and March 1st, 2021. The only exceptions, Ellis Act and health and safety. And I can only tell you this, my office handles unlawful detainer actions throughout the Bay Area. The Alameda court is the most dysfunctional in terms of operation procedures for pursuing unlawful detainer actions. I strongly advise you, before you even consider proceeding in Alameda, you really want to have a sober assessment of what is likely to occur and what is not likely to occur. Rest assured though, this moratorium is through the end of February. And so even though we had a discussion 30 minutes ago about the 15-day notice to pay rent or quit and the hardship, Alameda is a different animal. San Francisco is a different animal. You've got to recognize that the state gave rights to the counties to set their own moratoriums, and we do have to follow them. I will say this. I've had a client, they were not able to settle a case that arose well before COVID-19 that was at the court. And because there was no settlement, the court set the new trial for March of 2021. Now imagine you started a non-payment of rent case in January of 2020. Tenant hadn't paid rent from November through January. You started the process, COVID-19 arose, and now your trial is occurring in March of 2021. And remember, if it's a non-payment of rent case, you can't collect rent during this period of time, or you reinstitute the tenancy and you lose the case. That is where we are, folks, in how we handle landlord-tenant matters right now. All things being equal, you want to be very, very reticent about jumping into litigation right now, because I can't give you clarity about when matters will resolve and when there's a light at the end of the tunnel where you'll recover possession of the unit or you'll be able to accomplish the goal that you've set for yourself. So Alameda County, San Francisco, be very careful. Consult an attorney before you jump into a dispute. Here's a strategy. And this is one strategy that I think may be of interest to you folks who are carrying a lot of debt. And I am empathetic to you folks who are carrying a lot of debt. You have a client or a tenant who hasn't paid you April rent through August rent and only started to pay you 25% of September rent, October rent, November, December, and January. And now you're maybe in March and you're in Walnut Creek. So what do? Well, there's COVID debt, which is that debt from March through the end of January. And the state has indicated that you can proceed in small claims, and that debt is $15,000. And since small claims has increased the limitation above $10,000, you can file a small claims action for that debt. In March, assuming that the COVID pandemic dissipates and the Sacramento does not extend this law, you may be entitled to serve a 3-day notice to pay rent or quit. And that's on the right-hand side of the chart, post-COVID rent debt. If we go back to the 3-day notice in March, you can issue a 3-day notice to pay rent or quit. In March, the tenant still doesn't have the ability to pay the rent. Can you file an eviction action? Conceivably, yes. With a filing of a small claims action for the COVID debt and a filing of the eviction action for the non-COVID debt, you can serve the small claims lawsuit, serve the eviction action, and then hopefully either recover possession of the premises with some payment or negotiate a very favorable resolution for you. Is this more time consuming? Yes. Is it more cumbersome? Yes. But I believe that this is something that you need to consider, because I don't want you to miss out on getting a complete judgment for that large COVID debt. And I also want you to remember that once the pandemic is over, demanding unpaid rent through the traditional 3-day notice process will be permissible, and you can proceed with recovery of possession of the premises. The hope is you capture a judgment and capture possession, or through the use of both those lawsuits, you're able to gain a favorable resolution to the tenancy, either a vacancy or a commitment to pay all of this debt arising. I can't tell you whether this is going to be a successful approach until we start executing on it, but I want you to know we are thinking strategically about how to do it now, so that come springtime 2021, we're prepared for that opening. Now that's with a big asterisk. I certainly hope, as we all wish, that the COVID pandemic dissipates, the society becomes more physically, emotionally, and spiritually more healthy, and that we're back to boring, and that's recovery of debt, recovery of possession in a legal, ethical way. Buyouts. I want you to remember that nothing in this 20,000 word new law prohibits an owner from negotiating a voluntary move out of a premises from a tenant. Now, in different jurisdictions, there are different rules regarding how to do a tenant buyout. In San Francisco, there's a whole protocol. In Berkeley, there's disclosure requirements and a protocol. In Oakland, there's a protocol. What I want you to understand is during this COVID-19 pandemic, there's nothing prohibiting you from complying with the law and seeking potentially recovery of possession of the premises voluntarily in exchange for a waiver of the COVID debt. A little education will go a long way, which means this. You have a tenant who hasn't paid you rent from March through August. September is arising. They haven't paid you. You serve that September 30th document that we talked about at the beginning. And then in San Francisco, you send them the disclosure document required to commence buyout discussions. Tenant signs the disclosure document and you file the declaration and you say, look, you owe me $18,000 of unpaid rent. I know that there are new rules regarding collection of COVID-related rent debt, but I want you to understand that there is nothing that prohibits me from, I'm not going to waive the rent. I'm going to proceed with recovery through a judgment. And so I want you to know that I'm willing and able and ready to consider waiving some of that in the event you're willing to voluntarily vacate the premises. If done compliant with San Francisco law or done compliant with Oakland or Berkeley, you can get an agreement in place that you waive COVID debt in exchange for a voluntary move out. I want to emphasize that our office continues to do buyout agreements throughout the Bay Area, and we have found that this is the best solution to the COVID-19 crisis that is upon us on behalf of owners, because anytime you can have someone voluntarily move out, as opposed to remaining in possession, not paying the rent, and you potentially having to continue not collecting rent, and then maybe in the springtime proceed with an unlawful detainer action, you're much better off having a vacancy and resetting a relationship with a new occupant who hopefully will timely pay the rent, and you'll recoup your cash flow. So I want to emphasize, our office can provide you a buyout agreement rather quickly in strict compliance with Oakland, Berkeley, San Francisco, San Mateo rules regarding buyout agreements. And it is our strong bias that you consider this approach as a method of accomplishing goals that are not impermissible under the Tenant Relief Act of COVID-19. So by all means, I want you to consider that that dialogue done properly may result in the fastest, cheapest, smartest approach to recovery of possession. And that's something I'm happy to help you with. We are always doing negotiated agreements. And remember, you're not just agreeing to give them money to vacate, you're also seeking that they give up any claims arising out of the tenancy, including any lawsuits they may or may not have. So what you do is get a voluntary move out and you get no residue and risk of future liability. This is a key component to our COVID-19 strategy, because I'd rather negotiate a voluntary move out than have to chase someone for a COVID debt through small claims or chase someone through an eviction action when you know it can be very, very expensive to hire an attorney to proceed with an unlawful detainer action. And ultimately, the cost of the litigation is usually larger than the amount of the dispute. So being smart with your money is often about sacrificing expectation of collection of money, but getting the vacancy. We at my office are always focused on what's the smartest and best use of your resources. And sometimes it's walking away from the debt, but recovering possession of the premises as fast and as cheap as possible, taking into account attorney fees, time, and risk. So I want you to know that that is an available strategy. And for those of you, and we had on this webinar, we had 800 people sign up for the webinar. I think we got about 500 and something people who are participating in it. And I can guess that maybe 60 to 70% of you may have debt that has accrued. And you're wondering, what do I do? And my first suggestion is consider a negotiation done properly about a transition. And you may find that some of your tenants are perfectly willing and happy to transition back to family or transition out of the Bay Area in exchange for the waiver of the debt once they understand that you don't have to waive the debt in pursuit of a judgment under COVID-19 relief. So that is a bit of a soliloquy about the viability and the attractiveness of possession agreements. We are available to counsel you on this and will always do so in a way that's consistent with the law. With that, I wanted to say this. One, it is always my pleasure to be educating you folks about the law. I pride myself on taking complex information and trying to deliver it to you in a digestible format. COVID-19 presents intense difficulty with that aspect, especially since today I spent 30 minutes talking to you about the state law, and then we talked about San Francisco and Alameda County, and we had to forego that because they have their own particular nuances. I want you to know it's only going to get more confusing. It's only going to get more cumbersome until we're out of the pandemic. Keep informed. I am providing an abundance of information through social media, through e-blasts. I want you to be part of my network, whether you work with me as an attorney or not. My pride is in making sure people aren't making mistakes and stepping into a mess. And I can only tell you that there are brilliant attorneys waiting and thrilled when you make mistakes, because that creates an opportunity for them to feed their family through affirmative lawsuits against you. So being smart by educating yourself is something we pride ourselves on. I want you to recognize that we are going to post this webinar, I believe on YouTube, following it. But most importantly, if you're not signed up with receiving social media from me, by all means do so. Thank you very much for your time. It is, again, my pleasure, and please distribute the PowerPoint slide presentation to others. Help people learn about the complexity of this so they don't walk into a major, major problem. There are financial consequences to mistakes, and there are tenant attorneys waiting and willing to seize the opportunity to create liability for yourself when you make those mistakes. Right now, be cautious, be conservative, discuss your particular situation before you act. It is a very, very complex time period. Thank you very, very much for your attention. Again, it's Daniel Bornstein. I also want to emphasize that while I am giving this seminar, there is a whole team of people responsible for putting together this seminar. And I want to thank them because while I am the voice of it, there's a whole group of people who support me in this endeavor. And they are quality, wonderful people who are committed to also helping you folks get a sense of the law as it relates to COVID-related tenancies and the pandemic and where we go from here. Please be healthy, stay positive. We are going to get through this. And my hope is that come 2021, life returns to boring. Daniel Bornstein, again, thank you very, very much. And if you do have additional questions or issues that you'd like to present to me, just email me and I'll be happy to hop on a phone call with you, schedule a meeting with you, and provide you the information necessary. Thanks again, and I appreciate your presence and wish you all the best. Yeah.
Okay. Yeah, and then now you can close the X out.
I haven't muted.